Oh, so as a fair warning, please be reminded that all our Zoom tutorials are going to be recorded. So thanks for reminding me. And I missed the first 30 minutes. Well, those who weren't here, they missed the discussion we had. My apologies to those who end up watching this recording. I forgot to record. Just too excited to start talking to you guys. I forgot that we should be recording it. Okay. So, discussion question 1. Why is it important to understand the idea of a constitution as a living document or as representing a system of government? Any volunteers? Come on.
Hi. Am
Yes.
I coming through?
I could hear you. I need you to identify yourself because I'm having a hard time doing it here.
Sorry. I'm Marcus.
Marcus Beitzel. Beitzel. Okay, thank you, Marcus. Yes.
Okay.
Go on.
So to understand a constitution as living, it essentially means to understand that as times change and new laws are proposed, the idea is that the constitution and its meaning will change too, as in, yes. And it also should reflect the changes in the society and the morals and choices that it makes.
Yes.
Sorry.
And in that sense, Marcus, that kind of is in contrast to the strict textual approach to constitutional interpretation, where you follow what's in the text. Now, so that's one component of the idea of the living document of the or the idea of the Constitution as a living document. Now, the question I'd like to ask you then is that a good thing or is that a bad thing for a constitution? And we're speaking this time of a written constitution. So we're not looking at the Constitution as a system of government yet, although it is encapsulated in that idea. But speaking of a written constitution as a living document that is meant to change according to the changes in society, what's good about that? And is there anything bad about it?
I'm going to take a nuanced stance on this and say it depends on what the circumstance is, because sometimes a living constitution is a good thing because, as times change, perspectives change, and sometimes that means some laws seem outdated in later times and in over times. For instance, take a random example, the White Australia policy, which was considered constitutional in the early days of our federation, but nowadays is seen as really, really racist and not constitutional. But as to link into that strict constitutionalism you were talking about earlier, having a living constitution could be a bad thing because if you don't have a certain overlaying guidelines for your government, then your government could literally do anything that it wanted, like you could tax the internet for internet use, for instance, if a constitution did not allow. If a constitution didn't allow. Sorry, I'm getting off track here.
Yes.
Yes.
So, Marcus, you were actually saying that the problem with looking at the Constitution as a living document, which is subject to the interpretation of current leaders based on societal needs. Interpretation is subjective, and they can interpret it in a way that supports an action that may actually, in a sense, be wrongful. Is that what you're saying?
Yeah. Yeah, that's what I'm saying.
That's good.
It could also mean a bad thing, because if society changes to a more uglier, let's say, bigoted stance, as in I'm not gonna point at a specific example here,
yes.
but let's say that it becomes, a certain point in society, it becomes popular for I see in the chat box someone said pulling hands, but it becomes popular to hate on a specific group of people,
Mm.
If we did not have a constitution, then the government could just do that as to infringe on the rights of a specific group, which is popular.
Very good.
The idea of the tyranny of the majority.
Very good. Thank you, Marcus. You've brilliantly answered this question. Thank you. Now, there is a second component to the idea of a constitution as a living document. And this time, it is not about the constitution as a written text. It's actually the representation of a system of government. So when we speak of a living document, we're saying that the way to understand society or the workings or mechanisms of government is actually by looking at it as a constitution, in the sense that it represents a system of government. So in other words, you don't just look at the constitution, what is in writing, but you understand the laws, the fundamental laws of a land, by understanding the system of government. What can you say about that? If I might have another volunteer. Thank you very much, Marcus. Can somebody attempt an answer?
I'll give it a go.
This would be Samantha. Okay, thank you, Samantha.
I interpreted that to mean that because it's the supreme law of the land, it means that everybody is therefore beholden to the same laws. Mm-hmm. So it makes everyone accountable, including the government.
Okay. Now, but this idea of the constitution as a living document. So in other words, you might have a written constitution, but you might have a constitution as a living document in the sense that you understand what the government is, how the different branches of government interrelate, by looking actually at the framework of government. So in that sense, it's not so much the written text of the constitution, but the idea of a living constitution is that it embodies or represents how the government operates and how the three branches of government interrelate and interact with each other. In relation to the second sense of what a constitution is, which has been described by Ratnapala and Crow, why is understanding that concept important?
Are you asking me still?
If you could, yes.
I would believe that comes down to the idea of separation of powers.
Okay, go on.
Well, we've got the partial separation of powers. Correct me if I'm wrong. I don't have the textbook yet.
Yes.
But without the separation of powers, then you would become judge, jury, and executioner under the Constitution. And that's sort of how I interpreted it.
Okay, yeah. So I'm gonna move. Thank you, Samantha. I'm gonna move a bit quickly on this one. So the thing is, you might have a written constitution, and we understand often the written constitution to be the fundamental of the land, or fundamental law of the land, which isn't really the case all the time. Like New Zealand has a constitution, it is not the fundamental of the law of the land. It is just another ordinary law. Now, however, you might think that you know what the laws of the land is, or the laws of the land are, by looking at the written constitution. But in fact, if you look at the system of government, if the government is actually ran and controlled by a dictator or a cabal of leaders who have vested interests, you might think that there is a democracy. You might think that the power resides in the people, when in fact, power may reside in a few people, in a despot, or in a demagogue. So for you, therefore, for example, if you look at China, if you look, say, at Russia, if you look at Cuba, they may have written constitutions, and you would assume that you have the courts that can actually temper and control the activities of the prime minister or the president. But actually, that is not true, because if you have courts, if you have judges who are afraid to speak against the president because they might be killed or they might be arrested, then the constitution is really for nothing. So it's crucial that we discuss this, because Turkey, as I have pointed out last week, and some of you may have known, had a coup d'etat, an attempted coup over the weekend. Turkey has a constitution, but if you notice, President Erdogan, the Turkish president, he ended up actually dismissing about 2,700 judges of the courts. How does he do that if there's a constitution? So, in other words, the danger there, if you just look at the written text, if you just look at the written document, you might actually be misled into thinking that this is where power lies. This is, in fact, a democracy when it is not. So that the written constitution becomes an instrument for somebody to continue to take power. In fact, that's the Marxist view of laws, that laws are actually there to perpetuate the power from a ruling class. Okay? So let's just move along because I'm aware of the time. That's 6:48. Now, discussion question 2. Explain why some nations have written constitutions but do not have constitutionalism, while others have constitutionalism but no written constitutions. Which is of greater importance in a democratic society? A written constitution or constitutionalism? And if you want, you could answer the chat box, but I'm going to go straight now because we're running out of time. I'm going to ask somebody to try to answer this discussion question. Volunteers?
Constitutionalism is of greater importance because it sort of embraces all those higher ideals of human rights and egalitarianism and an independent judiciary. And you don't have to have a written constitution for that, but I suppose it's cultural as well. I mean, like you were just talking about before, there's a sort of connotation with the word constitution. To my mind, it always implies democratic ideals, but that's not true. There was a good answer by someone, and he used legislation from the Nationalist Socialist Party, the Nazis, and I mean, they had a constitution. North Korea has a constitution.
Yeah.
So constitutionalism is of greater importance to a democratic society.
So tell us a bit more about that, Jacob. What exactly is constitutionalism that therefore enables a democracy to thrive? What is it about constitutionalism as opposed to just having a constitution? So meaning you can have a constitution. Is it possible to have a constitution and not have constitutionalism, in other words?
Well, yeah, as I just said, the Nazis weren't a democratic sort of, they didn't espouse human rights or an independent judiciary or these things. So, but I suppose they weren't a democracy though.
Yeah.
But I'm slowly getting lost now, and I've run out of things to say.
Okay.
That's all.
Yeah.
What was that?
Can I interject there, please, Manu? So,
yes.
Constitutionalism is a number of things. So we're talking about the common doctrines of legality, the rule of law, comprehensive judicial review, separation of powers with greater emphasis on the separation of the judicial and non-judicial powers, representative and responsible government, and federal division of powers. Now, for us, we have a constitution which helps reinforce some of those items. Not all of them, but reinforce some of them. We also have the living form of the document with regard to representative government and the upholding of the common law doctrine, all these sorts of things. So I suppose we're a bit lucky in that we grow up with having all of it rather than, so we don't appreciate the difficulties of places like Turkey faces itself. I mean, Turkey goes through this every so many years. They have a coup, which is, they're generally more successful than not. And it just helps to reinforce the lack of, free and well-functioning government,
Very good. Thank you.
Oh, what do the Yanks call that? A government by the people, for the people, I think,
Yes, from Abraham Lincoln. Okay, thank you. So I'm just going to move on. Thank you there, Carl. I'm going to move on to question 3. What is objectionable about a government adhering to the principle of legality as a minimalist adherence to the rule of law? So what is objectionable about a government adhering to the principle of legality as a minimalist adherence to the rule of law? Volunteers?
It's essentially amoral, isn't it? Because you could have a law that would be, repugnant to most people. You wouldn't even need to explain why. Like, Oh, my headphones.
I was waving to the son of Samantha, or the nephew. I can't be sure. Sorry, Jacob. Go on.
Sorry. Yeah, I was just. What was the question? What is objectionable?
Government adhering to the principle.
The White Australia policy was that was sort of looked at these days to most people would be immoral and objectionable.
Jacob, let's begin by speaking of legality. What exactly is legality in the first place? What does it mean?
If it's written down in law, it's permissible. It's allowed. You can do anything as long as it's not prescribed by law.
Okay, so anything, if there is a law for it, then that becomes legal.
Yeah.
According to the principle of legality. Okay. So
like that minimalist, the minimalist adherence. If it's not balanced or tempered by everyone is equal, and those other tenets of the rule of law, like everyone else is equal, and the executive, the government are not above the law. The lawmakers are not above the law themselves, even though I think they are. If they can, but they don't do that. I suppose that's constitutionalism. It wouldn't be on if they did that. But I think they can. The stuff that it says, this does bind the Crown in certain bits of legislation, and this doesn't bind the Crown.
Maurice provided an answer here, and the way I understand it is that if it is written in law, then it is legal, no matter how deplorable it is. So in other words, if you use the principle of legality, you can use the law to support any deplorable, objectionable, immoral act that you want. So you can use the principle of legality to actually torture people, to actually put young children in jail. You can use it to force to criminalize same-sex marriages for as long as it's legal. You can use laws and the principle of legality to jail judges if you want to. And therefore it can become arbitrary, it becomes an oppressive tool to the leaders of a nation, especially if what you have is a less than democratic society where a nation might be ruled by a dictator. Okay, I'm not sure about the offshore detention, but that's an interesting topic there. Okay. Yeah, so from Janet, it's a good thing. There is no necessary quality of moral law involved. So the problem with the principle of legality is that you're just looking at what is legal, but isn't it actually crucial to talk about what is moral? Because to a great extent, the law although morality and law don't often intersect, but you might say that laws are meant to provide guidelines of conduct. And if the law therefore perpetuates conduct which is pernicious, which is actually bad, and therefore which is actually immoral, then what kind of law is that? So you can have law which permits slavery, for example, or you might even have a law that permits the marriage of young brides, because in some societies it's permissible to marry children as young as 10 or even 8. I've seen pictures of that. I'm not sure how true that is, but that can be legal, and yet it can be immoral. So we just have to examine that, because we cannot stop, even when we become lawyers, we can't avoid and stop thinking as if we're just lawyers and just look at everything on the basis of law. We always have to examine, even the morality of law. Because if it is immoral, then you really begin to wonder what is really the function of the law in the first place. Okay, now let's go to the final question. Why do you think is the Australian High Court loath to an encroachment of its judicial powers? Why?
They can't.
What's that?
They can't. They're not able to.
Who is not able to do what?
Well, it's not part of their it's not part of their jurisdiction to do that. Their jurisdiction is to operate as a what would you call it, the Supreme Appellate Court of the nation, but also to validate or not laws by government with regards to their constitutionality. They don't have it within their jurisdiction. the government doesn't have the power to erode it, and the High Court doesn't have, so therefore they can't by choice sort of pass it off. It's a protection of sorts, that there's no option available that they would be loath to. Well, I mean, by principle they should be loath to, which is the whole idea why it's there, but even if they wanted to, then they're not able to. It's outside their jurisdiction.
Thank you. Brad Corby, you say something about separation of powers. Is it okay for you to pick up the mic?
Is my mic working?
It is working. Would that be?
Oh, it is. Yes.
Okay.
I'm sorry. My camera wasn't coming up. Well, essentially, what was the question in regards to the prevention of absolute powers? Yeah, so the basis of the separation of powers is to create the doctrine of cross-checking, essentially, the lawmakers and then the people upholding the law. There's a separation of those powers. So people upholding the law, in essence, aren't making new law, but so the High Court, for example, gives the determination of the interpretation of the law that exists.
Okay. So when we say it is loathe, it's against the idea of an encroachment of its judicial powers. Why is that? B has said something there. B.
Due to the Westminster system of government that we have here, there's no complete separation of powers between the executive and the legislative. Therefore, as the third branch of government, it is very important for the courts to maintain their independence, and therefore they would fight any encroachment upon their ability to the judicial power.
That's right. So the Westminster...
I concur.
What was that? Brad?
I said I concur with my co-counsel.
Is that Brad there? Or is that
yeah.
Brad. Okay, yeah. So the problem, well, it's not a problem, but the way the Westminster system of government works, you will notice a kind of a fusion of governmental powers, both in the executive and the legislature. And imagine, therefore, if there is an attempt to encroach into the powers of the judiciary, such as when there could be some tribunal members who actually kind of act as judges, and they're exercising some judicial powers, and yet the administrative tribunals are under the jurisdiction of the executive. In that case, that becomes a total fusion of governmental powers in a single agency, and in that case, it's kind of anathema to the idea of democracy, where power is concentrated in the hands of a few individuals. And as Chai said, it's dangerous. So, okay, so it's 7:01, and we need to end the tutorial because I understand some of you will have other tutorials. So I wish to thank you for joining us tonight. I will post a recording of this Zoom tutorial in Moodle, hopefully tonight. And I look forward to seeing you again next week. So thank you, and good night, everyone. Bye.